If you are in the United States right now and your visa has expired, or you stayed longer than you were supposed to, what I'm about to tell you in the next few minutes could be the difference between staying legally in America and facing deportation. This is not a drill. This is not outdated information. This is happening right now, and you need to pay very close attention because missing even one of these options could cost you everything you've worked for in the United States. Welcome to U.S. Visa Today, your trusted source for the latest U.S. immigration news and USCIS updates that actually matter to your life. I'm here to cut through the confusion and give you the facts that could save your status in America. Let me be very direct with you. If you have overstayed your visa in the United States, you are in a dangerous position right now. Every single day that passes after your authorized stay expires puts you at risk of serious immigration consequences, including deportation, bars to re-entry, and permanent bans from ever coming back to America. Most people don't realize this, but USCIS and Immigration and Customs Enforcement have access to systems that track when your visa expired and how long you've been out of status. They know, and the longer you wait to fix this situation, the worse your options become. But here's what most immigration attorneys won't tell you up front, because they want you to come to their office and pay thousands of dollars for a consultation. There are exactly 3 legal pathways that allow you to potentially stay in the United States even after a visa overstay without facing immediate deportation. These are not loopholes, these are not tricks, these are legitimate legal options that exist within U.S. immigration law right now in 2026. And I'm going to explain each one in detail so you understand exactly what you qualify for and what you need to do immediately. The first legal way to stay in the United States after a visa overstay is through asylum or withholding of removal based on fear of persecution. Now, listen very carefully, because this is not for everyone, but if this applies to you, it could save your life and your ability to remain in America. Under U.S. immigration law and international treaties that the United States has signed, if you have a well-founded fear of persecution in your home country based on your race, religion, nationality, political opinion, or membership in a particular social group, you have the legal right to apply for asylum even if you overstayed your visa. This just changed in how it's being enforced because USCIS has updated guidance on credible fear determinations and the asylum application process, and you need to be very careful about the timing. Here's what most people don't realize. You must file your asylum application within 1 year of arriving in the United States unless you can prove that circumstances have changed in your home country or in your personal situation that prevented you from applying earlier. If you're already past that 1-year deadline, you're not automatically disqualified, but you will need to show extraordinary circumstances or changed country conditions. The critical thing to understand is that once you file a complete asylum application with USCIS, you are no longer considered to be unlawfully present for the purpose of accruing unlawful presence bars. Your case goes into a pending status, and as long as your application is being processed, you cannot be deported solely for the visa overstay. But, and this is a very important but, you cannot just file an asylum application to buy time if you don't have a legitimate claim. Frivolous asylum applications can result in a permanent bar from any immigration benefits in the United States for the rest of your life. This is serious. If you genuinely fear returning to your country because of threats to your safety, persecution, violence, or government action against you or your family because of who you are or what you believe, asylum may be your lifeline. You will need to gather evidence, document your claim, and present a compelling case to an asylum officer or an immigration judge. Many people in the United States right now, from countries experiencing political instability, violence against minorities, or humanitarian crises, have valid asylum claims and don't even realize it. The second legal way to remain in the United States after a visa overstay is through adjustment of status based on an immediate relative petition. This is one of the most powerful tools in U.S. immigration law, and it's available to people who overstayed their visa but have a qualifying family relationship with a U.S. citizen. Here's what you need to know right now. If you are the spouse, parent, or unmarried child under 21 years old of a U.S. citizen, that U.S. citizen can file an immigration petition for you, and you can apply to adjust your status to become a lawful permanent resident without having to leave the United States, even if you overstayed your visa. This is critical because for almost every other type of visa overstay situation, leaving the United States triggers automatic bars to reentry. If you overstayed for more than 180 days but less than 1 year, you face a 3-year bar. If you overstayed for 1 year or more, you face a 10-year bar. But when you're adjusting status as the immediate relative of a U.S. citizen, those bars do not apply as long as you remain in the United States and process your green card application here. This exception does not exist for people who are relatives of green card holders, only U.S. citizens. That distinction is absolutely vital. So if you overstayed your visa and you got married to a U.S. citizen, or your child who was born in the United States is now 21 years old and can petition for you, or you are the parent of a U.S. citizen who is 21 or older, you need to move on this immediately. The process involves the U.S. citizen filing Form I-130 petition for alien relative, and you simultaneously or subsequently filing Form I-485, application to adjust status, along with medical examination results, financial support documents, and evidence of the bona fide relationship. While your adjustment application is pending, you are in a lawful pending status, and you cannot be deported for the overstay. You can even apply for work authorization and advance parole to travel internationally while your case is being processed. But here's where people make catastrophic mistakes. If you leave the United States before your adjustment application is filed or before you receive advance parole, you trigger those unlawful presence bars, and you may not be able to return. Do not leave. Do not take that risk unless you have advance parole approval in hand. Also, be aware that if you entered the United States without inspection, meaning you crossed the border illegally rather than overstaying a visa, the rules are different and more complicated. You may still be able to adjust status as an immediate relative, but you might need a waiver or other relief depending on your specific circumstances. The third legal way to stay in the United States after a visa overstay is through cancellation of removal during deportation proceedings. Now, I know that sounds terrifying because it involves actually being in removal proceedings in immigration court, but stay with me because this option has saved tens of thousands of people from deportation and allowed them to get green cards even after years of overstaying. Cancellation of removal is a form of relief that an immigration judge can grant if you meet very specific requirements, and if the judge believes that your deportation would cause exceptional and extremely unusual hardship to your U.S. citizen or lawful permanent resident spouse, parent, or child. There are two types of cancellation of removal, and which one applies to you depends on whether you are a lawful permanent resident or a non-permanent resident. For most people watching this who overstayed a visa, you would be applying for non-permanent resident cancellation of removal, which requires that you have been physically present in the United States for at least 10 continuous years, that you have been a person of good moral character during those 10 years, that you have not been convicted of certain criminal offenses, and that your removal would result in exceptional and extremely unusual hardship to a qualifying U.S. citizen or green card holder relative. This is an incredibly high standard. Exceptional and extremely unusual hardship means much more than the normal hardship that any family would experience from separation. You have to show that your qualifying relative would suffer consequences far beyond what others experience. This option is not easy and it's not guaranteed, but here's the reality. If you are placed in removal proceedings, either because ICE arrested you or because you were referred to immigration court after a denied application or for another reason, cancellation of removal may be your last and best chance to stay in the United States legally. Many people have won cancellation of removal cases by presenting detailed evidence of their qualifying relatives' medical conditions, psychological dependence, financial reliance, country conditions that would affect the relative if forced to relocate, and the deep ties the applicant has built in the United States over 10 or more years. Immigration judges have discretion to grant cancellation even if you meet the requirements, so the quality of your evidence and the persuasiveness of your case presentation matter enormously. Here's what most people don't realize about cancellation of removal. While your case is pending in immigration court, which can take months or even years depending on the court's backlog, you are not deported. You have a pending case. In many situations, you can apply for work authorization while your cancellation case is being heard. And if the judge grants cancellation of removal, you become a lawful permanent resident immediately. It's a green card granted by the immigration judge. That is a life-changing outcome. Now, let me be extremely clear about something. These 3 legal pathways are real, and they are being used successfully by thousands of people right now across the United States. But they are not simple, and they are not automatic. Each one requires that you meet specific legal criteria, that you file the correct applications with the correct evidence at the correct time, and that you navigate a complex legal process where mistakes can be catastrophic. USCIS Update 2026 guidance has made some of these processes slightly more favorable in certain respects, but also more scrutinized in others, especially around asylum claims and adjustment of status interviews. If you are currently in the United States and you have overstayed your visa, you are running out of time. Every day that you wait is a day that your options may be narrowing. If you think you might qualify for asylum because of what you would face back home, you need to start gathering your evidence and preparing your application immediately. If you have a U.S. citizen spouse, child, or parent who could petition for you, you need to start that process now before something happens that puts you in front of an immigration officer or ICE. If you've been in the United States for close to 10 years or more and you have U.S. citizen or green card holder children or a spouse, you need to understand your potential eligibility for cancellation of removal in case you ever end up in immigration court. The worst thing you can do right now is nothing. Hiding and hoping that immigration authorities won't find you is not a strategy. USCIS and ICE have more resources, more technology, and more coordination than ever before. Enforcement priorities are changing constantly, and people who thought they were safe because they've been here for years without problems are suddenly finding themselves in detention, facing deportation. You cannot afford to wait until you're arrested to start thinking about your options. But here's the hopeful part, and I want you to really hear this. The United States immigration system, as complicated and as harsh as it can be, does have pathways for people who overstayed to fix their status and remain here legally. Thousands of people every single year successfully navigate these options with the right guidance, the right evidence, and the right legal approach. You are not automatically doomed to deportation just because your visa expired. You have options, but you have to act on them. One more thing that you absolutely need to understand. Do not trust anyone who promises you a guaranteed outcome or who tells you they can fix your overstay with some kind of shortcut or secret process. There are no shortcuts in U.S. immigration law. There are legitimate legal options, like the 3 I just explained to you, and there are scams. Immigration fraud is rampant, and it destroys lives. If someone is telling you they can get you papers quickly for a fee without filing actual applications with USCIS or the immigration court, run away. You will lose your money and you could end up in criminal trouble on top of your immigration problems. The green card update today and the latest USCIS news shows that immigration enforcement is becoming more aggressive in certain areas, while some application processes are becoming slightly more streamlined for people who qualify. What that means for you is that having valid legal status or a pending legal application is more important than ever. If you're out of status with no pending application, you are extremely vulnerable right now. So here's what I need you to do right now after watching this video. First, figure out exactly when your authorized stay expired and calculate how long you've been out of status. That number matters for determining which options you have and what bars you might be facing. Second, identify whether you have any qualifying family relationships with U.S. citizens or green card holders. Third, think seriously about whether you have any fear of returning to your home country that could form the basis of an asylum claim. And fourth, consult with a reputable immigration attorney who can review your specific situation and tell you which of these options is realistic for you and what the process and timeline would look like. Do not try to do this alone. Immigration law is one of the most complex areas of federal law, and the smallest mistakes can have permanent consequences. A consultation with a qualified attorney could be the best money you ever spend because it could be the difference between staying in America with legal status and being deported with a 10-year ban. I know this is scary information. I know many of you watching this are terrified about what might happen to you and your family, but knowledge is power. Understanding your options is the first step to protecting yourself. The fact that you're watching this video right now means you're taking your situation seriously and looking for real answers, and that puts you ahead of so many people who are burying their heads in the sand. If you found this information valuable and it helped you understand your options after a visa overstay, I need you to subscribe to US Visa Today right now. Hit that subscribe button and turn on notifications because we bring you the latest U.S. immigration news, USCIS updates, visa updates, and green card news as soon as they happen. We're here to keep you informed and help you protect your immigration status. Drop a comment below and tell me what type of visa you have or what your immigration situation is. Are you worried about overstay? Do you have a U.S. citizen relative who could petition for you? Let me know in the comments because your questions help me create content that addresses the real issues you're facing. And please share this video with anyone you know who might be in the United States on a visa or who might have overstayed because this information could literally change their life. Share it with your family. Share it with your friends. Help spread the word. Because staying informed and understanding your legal options is how we protect our communities. Thank you for watching US Visa Today, and I'll see you in the next update with more critical immigration news you need to know.